audio feed to the interpreting booth. This is why we're experiencing this lapse in interpreting. Well, thank you very much for sticking to your allocated time. And now I will give the floor to Leandro Núñez García, lawyer by the University of Coruña and with a master's on the communications law by the University Carlos III of Madrid, partner of Audens, new technology attorneys. Since 2012, he works on data protection, intellectual property, privacy, and he coordinates the international relationships of this firm. He was also representative of the Spanish Data Protection Agency, as well as the Article 29 group of the United Nations, also for the European Union and the different international conferences on data protection and privacy. Among the final articles of the Audens blog that he has published are matter of waiting, analyzing the decisions of the European Court about the right of oblivion, the right of being forgotten by search engines such as Google. And now I'll give the floor to Mr. Núñez. Well, first of all, I would like to. My father used to say that it is good to be appreciative, so I would like to thank Infotech Areneji for having invited us to be here. I'm gonna customize this, and that is not something that is okay at times because we leave the people out. I'd like to thank Vilma because thanks to her I am here, and thank you all for attending. It is my turn to discuss the conflict. We might call it a conflict between big data and privacy. It is a topic that Mr. Jansen discussed a moment ago from the standpoint of privacy and confidentiality as necessary elements to produce trust in the use of these tools by citizens, and also big data is a technology that, as Javier just presented, produces important benefits, economic benefits, improves efficiency, and gives rise to better development. So on one hand, we have trust and human rights, and on the other hand, we have efficiency and development, and we need to find a compromise or a balance between both aspects. And to do this, we need to know what big data is and what privacy is. Big data, well, all of us here know what this is. Therefore, let me begin by presenting what are the basic principles of privacy and data protection, because only in that manner will we be able to reach that balance. Data protection is a fundamental right today. It's a constitutional right recognized in most countries in the world. It is true that in many it is not yet a recognized right, but there are many regulations that are being developed in this field. Historically, it comes from the 70s with the beginnings of informatics or IT, when IT was precisely about perforated cards to do calculation work. These standards began to be created due to the fear this instilled in the population. So if you visit the French data protection agency, the entrance has a vinyl print that shows the reason why that agency was created, because the citizens wanted their data to be protected. There were public demonstrations, and this prompted a regulatory shift why this agency was created in the 80s. This, in turn, produced concern because IT had a tremendous potential that we can now appreciate, and there was the risk that some especially harsh regulations could be slowing down technology development. In 1981, a decision was issued, and also a directive of data protection of 1995 attempt to guarantee the fundamental rights of the population, while also achieving a standardization to make basic rules through which the countries could be based, that could also foster a free exchange of data within the European Union's scope to guarantee that the fundamental rights of citizens which data were flowing in that territory were protected.
After this development of standards has expanded to a point in which it has reached Latin America in a very clear way through examples, paradigmatical ones such as Mexico, who has been able to obtain a balance between the privacy of say the European notion and the U.S. notion, which is a bit more consumption focused. And here, well, there's a federal law for the protection of data that attempts to find a balance between this, but we're not speaking of private people with data, but of public administration. In this sense, the fact that this is is fundamental because governments have the obligation of respecting this and of guaranteeing these three principles or characteristics that are the basis of fundamental law. The fact that you cannot renounce to it, the state cannot alienate it, and it never prescribes very well. These characteristics in mind, that this is a constitutional right, well, we'll have to see whether it consists of, well, a faculty of control and over the data control, because the holder of the right has a capacity of deciding who is treating his data, what for, when, and for disposing of it, because he has a series of rights that he can use against those who are using and possess this information. And in this sense, the Mexican norm is quite quite good in the sense that that he speaks of property. The person continues to be the holder of the personal rights, and what he does is to put them in the hands of a person who possesses it, and within the limits that he's told the holder that he will have them. There's a principle of consent on the basis of previous information. That's the key. The truth is that consent is not basic, because frequently we have legal exceptions in which through other mechanisms the information can be treated. In the case of public administrations, this is paradigmatic. Most of you, if the Ministry of tax comes to you with the consent, who came and asked you for your consent to pay your taxes, many would not give you. So in the sense of public competencies and other situations, statistics is one of them. We may treat or discuss this information and properly function. Very well. On one hand, we have a capacity of control of the citizen and the individual, and what the norms do is generate a series of obligations in which they recover data. Obligations that are quite similar. Well, perhaps the similarity from the legal standpoint is not adequate, and it's possible to say that this is similar to depositing your money in the bank. You can take this money to the bank, you can work with this, but in the moment that the person decides to recover this, the bank needs to give it back. So you are depositing your data in a sense, and they need to protect it from different point of views, not from the point of view of safety, but also in the point of view of confidentiality and the sense of ensuring that they are updated, that they respond to the reality, that they are truthful. Taking this into account of what we need to do, we must say that the person who holds the data of an individual has to comply with the law. The law applies to him, and this in Mexico, this is no exception. In the case of public administrations that are subject to the law of protection from transparency of 2003. So this is in detriment of the laws of the federation. So the issue is, if everyone who possesses data is subject to the obligations established by privacy norms, if we want to use personal data when we do big data, we will be subject to this legislation. In this sense, the truth is that it's very impractical, because the treatment done to this data in the framework of this technology requires cross information from different sources. It requires very profound analysis, which is hard to explain to citizens, and which, aside from this, would impose a series of obligations when we cross information with of some organizations with others. This would be very hard to do. So the ideal way in which is done is to not work with personal data. If I don't use personal data, the law does not apply, so I can do anything I want with them with certain limitations in terms of competency and intellectual property, etc. But this is the idea. So if we're able to remove personal data from the equation, then we avoid a series of barriers here. And this is something that our norms and our laws recognize in Europe and in Mexico. If we go to Article 22 of the Law of Transparency, we see that one of the options for the non-appliance of these norms is to create procedures through which you cannot associate the person to his data. So this is what we call anonymization, and that's how you bring personal data to big data. So what would we need to do if we have personal data? We try and have them not to relate them to an individual, but this doesn't cover all of the problems we face, because in order to anonymize them, we first need to have them, and to obtain this information at the moment we collect it, we are referring to data which, well, we need to have legitimacy. So we need to have consent, we need to have legal authorization, basically. So basically this obtaining data through illicit means is key when it comes to big data, because we have legislations that closes our possibilities and closes them. And well, from a perspective and from the internet perspective is key. It's not the same if you have data that's on internet, which is public. This is not the same than the fact that we can use it. These are different information. We need to have the legitimacy to use the information that's available there, or that we need a norm for this. So this is a serious norm. How should we create the association? Well, it's possible that you consider that by eliminating name or the address of a person is anonymized, but not true. If it's a small town where there's only one school and we speak of A, B, and C, the principal of a school, of a town, then he's easily identified. So by associating this person with his name and his identity, and this cannot happen. So it's fundamental that this association is reversible. And to do this correctly, we need to have protocols such as I will tell you in the future, or in a few moments. So these first two obstacles, this need to obtain information legitimately to deassociate it, and this complete, correct, irreversible disassociation, they are easily saved, and we're doing it. Through the private sector, most of the information that we treat through big data comply with these two norms. The issue is this: we have the data we've collected, we've anonymized them, we've introduced them in a system that's capable of this analysis, and that what generates is a series of information that can be of great use. Information that's segmented, information that is that we can create profiles from, and which allow us to make decisions, which is ultimately what this is all about. And this leads to privacy norms, because even though it's true that we've worked through this, we need to when we want to apply public policies, this will be applicable once again, and once we apply it, we will have the principles. We need to consider principles of legitimacy. So if to any of you I apply a specific profile, and you're susceptible to contracting a certain disease according to the data that we have, then at a certain moment, this information will be personal again, and we will have we will need legitimacy to do this, and this isn't always easy. How to comply with this? Well, from a statistical point of view, it's relatively simple because it's not about applying policies to a person specifically, but to apply to knowledge, ideas on what kind of policy can be applied to a collective, to a delegation, to a municipality, whatever the region we're referring to. If it's one person, more than one person, if we can't identify a single person, we won't have any difficulty in applying this to the collective. But if we're referring to a collective, yes, let's say this is something that will probably happen, in which through our authorities and our tax terms, they'll use tax evaders through big data, and they're doing this already. So the key is this: to have legitimacy to apply the data. What happens that on many occasions, what this generates is information that is not necessarily exact. These are possibilities that may be very high and will be applied to citizens and generate negative consequences which are not truly applicable in reality, or that can lead to legal consequences that are non-desirable. How can I combat this? Well, I have 4 ideas. The thing, if we want to use public information for big data, ideally, the information needs to be anonymous from its origin. If we want to, for instance, for the INEGI to work as a collector, repository for this information, then the information that's delivered to it must be anonymized in order to avoid temptations. It's not about a single organ to have all the information of citizens, but to have the useful information needs to be regulated use, and it needs to be controlled in order to avoid abuse. There needs to be a series of security mechanisms that allow us to avoid it being modified and abused by third parties, because we're all going to believe a machine. If a machine is manipulated, then what it says is not what it should say. Then you must explain to citizens that the issue of transparency, well, is very important. So is communication. It must be traceable. All the information must be traceable, because the principle of delivering accounts is key or crucial when it comes to public information. You have a long experience in transparency laws that contribute to generate a society that better understands the mechanisms behind its institutions, that makes it more democratic, and it helps avoid corruption. So it's the same thing here. So as long as there is no normative, well, there's no series of norms, we need to be prudent. In other words, we need to know what the possible impact of certain policies may have on citizens. Why not? If we can't explain to people that what we're doing is beneficial, that this is innocuous, in a sense, what we might generate is a big brother symptom. Big data, big brother, there's not much of a difference, and this might happen. So how do we do this? There's 2 principles that we need to apply in terms of privacy, which I think are very important. One of them is privacy by design, is to generate tools that respect privacy by default, and which are by and which may be managed by people who may not have legal expertise, but the fact that they are designed in such a way contribute to, even if they don't know the legal regulations, they can comply with this. And also, proportionality principle, need to know, is not the same as nice to know, and that's how this should work as well. It's not about obtaining everything. We need to have necessary information to generate the policies that we are trying to comply with. So there's a change of paradigm. There's a changes in paradigm occur in the legislative. So in this case, it's, well, what do we need? Not all technological change needs to have a legal modification, because the principle for these norms can be applied and must be applied. But the truth is that we must not close the door to changes that may help people. So we must do this with certain prudency, because if we legislate in a hurry, this is not good. Otherwise, we will advance through patches that are legal, that try to solve concrete situations that, from a perspective of material law, are useful, but not from a positive law, generate legal safety. I think there's a possibility of obtaining an equilibrium between human rights, efficiency, development, and such a way that both big data and privacy can coexist peacefully, and this will benefit society if we were able to attain this, and not just you, the people here will be important stakeholders in this process. Thank you very much.